this court ordered that all exhibits and witness lists be exchanged by August 14th. Our office filed the necessary documents to Mr. Macek on August 11th. We filed with the clerk of court. We sent him to both 1515 Smelter Avenue and his PO Box 791 in duplicate, anticipating that Mr. Frank would allege that he had not seen them. So there's two different mailings we sent out August 11th.
And that,
right, Mr. Macek, do you want to respond to that?
I do. He kept saying, Mr. Frank, I'm Mr. Macek. I haven't received anything. That's what I'm saying.
Mr. Flaherty is an officer of the court, and he's just made an offer of proof that I find credible that he delivered those documents to you. Throughout the entirety of this case, I have been more than fair with you, Mr. Macek. I've continued hearings. I've gone out of my way to
I'm
explain
objecting
proceedings
to
you.
that. You have not been fair one bit throughout this entirety. You have ignored all.
You have remedies of appeal. You have remedies of appeal. You can ask the Montana Supreme Court.
I can. I understand that. However, we shouldn't be at this point. You have abused all your power. So I don't understand how
That's
this is even
legally and factually wrong.
No, it's not.
You're legally and factually wrong. I am not allowed to give legal advice to a self-represented litigant, but I've extended extreme procedural fairness to you. I think that a detached, neutral observer might find perhaps I've been too fair with you. I've given you every chance to meaningfully take part.
Shall we describe how this property was acquired by the plaintiff?
I will take testimony from both sides. We'll develop this on the record. But what I'm trying to say is, when it comes down to assessing the credibility of Mr. Flaherty when he says he delivered it to you, and the credibility of you saying you haven't gotten it, I'm at a point now where I find his word on that issue more credible than yours. So we're going to go forward because he said he mailed it to you, and I believe he did.
He said he mailed it to Mr. Frank. I am Mr. Macek.
Let me finish.
You have not let me finish anything on this first statement. You interrupted me from go.
There's been willful ignorance on your part. And on
same on your part. Same on your part.
That's ludicrous.
It's absolutely fact.
Well, you and I aren't going to have. We're not going to have a debate on this record. I'll entertain your testimony and rule on the matters. But we're going to go forward today. He says he mailed it to you, and I find that credible. I find your statement that you didn't get it not credible.
I object.
Well, your objection is noted for the record. With that said, did we get this witness sworn? I can't even.
I object this property. I object it all.
For the record, Your Honor, I also emailed Mr. Frank on September 2nd.
Mr. Macek,
Yeah. Sorry,
I have not received anything as Mr. Macek.
Mr. Macek's email handle is jason.frank10@gmail.com.
All right.
I sent him an email saying I mailed them out. Please confirm if you did not get them. I haven't seen your exhibit list. Let me know if you can supplement if needed. And I attached the order setting the hearing in that email as well. And the entire quote was, Jason, I have not seen your exhibit or witness list. I have mailed mine and you should have it now. Please supplement if
and
needed.
Do you have a read receipt on that email? Is there a read receipt on that email? No?
Just one moment. One moment, but let's just take a deep breath. Here's the situation.
Fraud, waste, and abuse.
All right, listen to me. I will entertain your objections to accord you procedural fairness. If you're going to just rant on the record, I'm going to hold you in contempt.
I objected, and you didn't even let me finish. You interrupted me, like every other hearing we've had.
I interrupted you because I'm the judge and I'm running this court. I'm going to give you... Stop. I'm going to give you a chance to object, but I'm not going to let you keep ranting on the record that's not in the form of an objection. So if you want to render an objection now, tell me and I'll rule on it. But if you're just going to keep having open mic night from your place, I'm going to hold you in contempt. So if you want to make a record, you can. If you want to rant away in my court, you can't. So that's where we are. What's your objection?
To this whole matter.
You have the floor. What do you want to tell me?
This property was acquired by you, the plaintiff, due to you using fraud, waste, and abuse by giving me initially the property. You withheld my divorce decree knowing that that divorce decree was all I needed to give to the banks to get the property in my name and the plaintiff's name off the property. You withheld that divorce decree for over 90 days, even though within that 90 days, I put in a request to your courts to get that final divorce decree so I could move on and get the property in my name. At that point, this wouldn't be an issue. I would still have tenants at that point, possibly. Who knows? We wouldn't know at this point because you tied my hands mid-case at the request of the plaintiff after you took the property from me. That's my objection. So this is fraud, waste, and abuse. This shouldn't even be an issue. Back in 2017 in our first hearing, this was explained.
Mr. Flaherty, what is your response to Mr. Macek's objection?
It's hard to giving deference to a pro se litigant not artfully pleading an actual objection. His objection is that had he shoulda, coulda, woulda done something years ago, he's not sure how it could have worked.
Objection on that. That's not a shoulda, woulda, coulda.
Disposed of in a different manner.
He's just responding to your objection. I'll entertain your follow-up, but let him finish, and then we'll go back and forth in orderly sequence.
We're not really operating it under reality. The reality was this court gave extreme deference and told Mr. Frank to provide some effort on refinancing the house or come back to court with an affidavit or something. He testified that he talked to someone at a bank for less than a minute. He never got documentation, never got a loan application, but he could possibly refinance it if needed. And if I recall correctly, this court said, if you need help, come back and do something. That time elapsed. We never heard from Mr. Macek. He never once brought in a letter from a bank saying if only the decree was issued, we could get this refinanced. So after an additional 60 days of no efforts, Jason Macek made his own bed, and he knew what was going to happen under the real property award because this court gave him clear, unambiguous instructions that if he doesn't help himself, that he's not going to tie up credit and resources for his ex-wife indefinitely. So that happened. The clerk's deed was issued, and the property is now at issue being further being litigated because Mr. Macek has failed to cooperate. So the order setting hearing in this matter, we noticed up Mr. Frank wanted four things, wanted to know what we're addressing: the diverted bail money, the return of the deposit for the tenants, the real property, and the damages assessed prior to Ms. Macek's or Ms. Frank's ownership, and then the property and the damages after her ownership regarding the sale of the house at that property. So we got to dispose of those two issues along with the issues of the bail money and the deposit. So that's what we're here to talk about. Mr. Frank has not filed, or Mr. Macek, excuse me, has not filed a notice of appeal on any of the orders previously written, despite an entry of judgment being issued almost 2 years ago. There hasn't been one effort to appeal this to any higher court other than Mr. Macek to come on the record and tell you that it's an improper order. He understands the appeal. He makes objections. The fact that he hasn't appealed speaks volumes to the merits of his objections.
All right. Mr. Macek, I told you I'd give you a chance to respond to his response. So what do you want to tell me?
Yeah, that made no sense to what my objection was. That made no sense.
Well, I'm going to overrule your objection.
Well, of course you will. Because that, I mean, that...
Okay, don't get with me or you're going to be in contempt. You're on a short leash today. I'll give you a chance to argue your case, but we're not going to debate it. You can make a legal argument, but you cannot just have open mic night in here. You know better by now. We've been going on and on in this case.
But
so
that was my response.
Don't debate me. Overruled.
I would like to call.
Well, I want to explain my ruling for the record in case there is an appeal. So Mr. Frank has tried to express that he felt the original orders. Very well. Mr. Macek, it's been confusing for all of us, the fact of your name change, but nonetheless, Mr. Macek has essentially made a legal objection disputing the validity of the proceedings. Mr. Flaherty has responded, noting Mr. Macek's failure to timely appeal at several phases of the case. So the objection is noted and overruled. You're out of order. We're going to take the witness now. I ruled, and that's the end of it. You can appeal it if you want to, but we're going to have some testimony. Mr. Flaherty.
Wasn't sworn in.
All right, we need to swear the witness in, Your Honor.
All right. Please raise your right hand.
You solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record, please?
Tracy Tamaris.
And Tracy, how do you know the parties today?
I rented a property at 451st Street South from Jason Frank.
Okay. And he was the landlord at the time that you started that?
Yes.
And what did you guys agree upon as rent and deposit?
I paid $1,800 for rent and $1,800 for deposit on May 1st of 2017.
And there came a time where the ownership of that property changed, and are you aware of who your new landlord became?
All of this, well, I learned that there was a new property, the property had changed from you.
Okay. And do you recognize Miss Frank here today?
Yes.
Okay. And was she your new landlord?
Yes.
Okay. And did you continue to pay rent to her?
Yes.
At the time, have you ever received the $1,800 deposit back from Mr. Macek?
No.
Have you asked him for that deposit?
Yes, when the property changed hands.
And what did he tell you?
He told me he was going to give it back, but every time I would message him, he would ignore my messages.
Can I object right here?
Just one moment. He's rendered an objection. What are the grounds for your objection?
Falsehood, lies. I have text
So-
receipt from her stating not to pay him back from anything. And I don't have any text or anything from them, calls or anything
Okay.
from them.
Mr. Macek, I'm going to overrule your objection. Your remedy is you're going to have an opportunity for cross-examination. That is your chance to explore the truthfulness of any witness's statement on the record. So you'll have a chance to do that. And at the close of evidence, I'm going to take argument from both sides. So I'm going to overrule your objection. You'll have an opportunity to develop the record down the road. Very well.
And real quick, Exhibit E, we filed with the court previously. It shows a receipt of May 17th for $1,800 for deposit, and the other $1,800 to Tracy is for rent from May 1 to June 1 of 2017. Is that the rental monies that you described it today?
Yes.
Okay, that's the original receipt, actually.
This is the original receipt.
Okay. Your Honor, I would move for the previously marked Exhibit E to be admitted.
Mr. Macek, do you object or stipulate to the exhibit?
I can't even see the exhibit.
All right. I'm gonna allow it to be admitted because I previously found the offer of proof from Mr. Flaherty credible that he sent the exhibits. So this exhibit is now admitted.
And Tracy, after that time, were you aware that Mr. Frank was?
Well, just a moment. Do you have the original for the court?
I filed it. It should be filed in an original on August 11th in the court file. But I can change it. Can I actually take the original, Tracy?
We'll need the originals filed. So unadmitted exhibits aren't going to go into the court file because there's a risk of confusion.
And actually, I'll make this, actually, sorry, my staff is better for me. They have a binder of original witness list. If I approach, Your Honor, there is the witness list that we filed, and then they're marked out in a binder.
But what I think I'll have you do is just provide them one by one as they're admitted, because I don't want to have any file confusion between what you're presenting and what's been admitted. So this exhibit is in, but I don't want to have the entire binder go into the court file. I'm going to evaluate the evidentiary basis for each exhibit singly during the course of the hearing.
So at some point, Ms. Damaris, did you learn that Mr. Macek was taken into custody at Cascade County Jail?
Yes, I was.
And how did you learn from that?
His sister called me.
Okay. And would and why would Jason be looking to you to bail him out?
Because he was at the house.
One moment. Did you render an objection, Mr. Macek? All right. I'm going to ask the witness to please repeat her statement.
I learned that Jason was in jail by his sister.
Okay.
She had called me and stated that Jason had gone to jail and was wondering if I was going to bail him out.
And why would Mr. Macek look to you for bail money?
Because the house was transferring from him to Stephanie, and I still had all the rent, and I said if he had gone to jail, I would bail him out.
Okay. So the bail amount, how much did you provide to the bondsman to bail out Mr. Macek?
I'm not exactly sure how much it was, but I know it was $500 and some dollars.
Okay. But at least 500, probably five and some change.
Yeah.
And what was your understanding in providing that to Mr. Macek?
That he was going to give me the money back when he got out of jail.
Okay. And was that going to offset rent at all, since you were owed him rent money?
I didn't owe him any rent money.
Okay. But you didn't owe him at that point. But was it your understanding that he was going to offset because you had rent money saved, you hadn't paid that month's rent, that would come out of that rent money?
It wasn't, he was supposed to just give me the money back.
Okay.
So that I had all the rent to give to Stephanie.
Okay, right. So if you had $1,800 to rent pay, you gave $500 to Jason. When he got out, he'd give you more, so you had full rent to give to Stephanie.
Correct.
Okay. And that was known to him at the time?
That was the agreement.
Okay. After he got out of jail, did he give you that $500 back?
No.
Were you able to pay the full month's rent to Stephanie?
No.
Have you been able to return the deposit to Stephanie from Mr. Macek that you had put down originally on the house?
No, he never gave it back.
Okay. And another issue we have is the condition of the property and the rehab that we have to do to get it to sale. When you moved into the property, I reviewed your previous statement. Was that property, you moved in May of 17, and Jason was the only owner and the only landlord, is that right?
Correct.
Was the property in substantially the same condition at that point as when you left it in 2019?
Pretty much the carpets were already, he hadn't cleaned the property when I moved in.
Okay. And you maintained it at the level that he'd presented it with you. And my big question is, did you contribute any more destruction, damage, filth to the property during your owners or tenancy, or was it the exact same-ish when you took occupation of it?
No, not the master bedroom.
What about the master bedroom?
The carpet.
Okay, that was worse.
I take accountability for that.
Okay.
But other than that, that's like we had to shampoo all the carpets. and everything when we moved in.
Okay. So you can tell this board comfortably that other than the carpet in the master bedroom, you maintain, when you went back to Stephanie and you vacated the premises, it was materially the same condition as when you started that rental.
Correct.
Okay. That's all the questions I have for you. Thank you so much for being here today.
So, Mr. Macek, do you have any cross-examination for the witness? All right, you may now ask your questions.
Well, now that I think about it, probably the downstairs, the marker on the wall was done by my grandkids. And the master bedroom bed, the carpet.
Your Honor, I would object that Mr. Macek just testified in his questioning about specifics of the house, including stairwells and images that he must have seen, and he is questioning the witness, claiming that he has not seen these photos, but he's now disclosing specific photos that were in our exhibits of stairwells.
All right, I will note that. Okay. Well, I'll let you testify in a minute, but we need an orderly process. Well, you are, and I'm going to give you some procedural latitude as I always have, but I need to get this witness's testimony concluded. You'll have a chance to be sworn and testify. Mr. Flaherty, you've made that point and you can reference that in argumentation. So with that said, Mr. Macek, you can continue your cross-examination of the witness. This is your chance to ask her questions. It's not your chance to talk. Make it a question. I won't interrupt you. Make it a question. I won't interrupt you. You're giving a narrative. Just make it a question. A question would be like, what's your name? Where do you live? Isn't it true that you're wearing a shirt? That's a question. When you give me a paragraph of content, that's a statement. So you're an intelligent man. Make it a question.
The upstairs carpet and in the living room and the downstairs carpet in that living area, yes, had black spots. I don't know what you're talking about with the stairwell.
Okay, so she said it wasn't black. You can testify later and say it was black, but I won't entertain an argument on it. Do you have another question? Okay, so the question was the middle white or black?
The middle. I don't know what he's talking about with the stairwell. I really don't. I have no idea what he's talking about. Yes, and then they fell down and we reported it to you. Yeah, we had made a statement. No, I never said that. I don't recall ever saying that.
All right. Thank you, Mr. Macek. Mr. Flaherty, does that prompt any redirect?
No, Your Honor, this witness may be excused.
You may be excused. Thank you for your time. You're free to go. Mr. Flaherty, you can call your next witness.
I would like to call Paul Schuster, Your Honor.
All right, Mr. Schuster, if you'll please step to the podium and be sworn.
Please raise your right hand. You solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very well, Mr. Flaherty.
Thank you, Your Honor. We're gonna have to flip tables. Mr. Schuster, can you state your name for the record, please?
My name is Paul Schuster.
And do you own a business here in town?
Yes, I do.
What's the name of that business?
Keystone Builders.
And what does Keystone Builders specialize in?
Pardon me?
What does Keystone Builders specialize in?
A residential contractor.
Okay, and how long have you been a builder here in town?
Well, probably over 25 years.
And I'm looking at a proposed Exhibit C, which is a contract or a bid to repair the home at 451st Street South for Stephanie Frank. Do you know who prepared that bid?
I did.
And what did you do in order to get an idea of the damage and assess this contract?
I walked through the house.
And did you spend a sufficient amount of time in the house to make sure that you got all your right measurements and evaluated all the damages?
Yes.
If you could translate to us what you found in the house, could you describe generally the condition of the property and whether or not it needed rehab or whether it was good to be on market as is?
Okay, the house was in a state of disrepair to every room of the house. The carpets were, and the flooring was in such a state of disrepair that it was beyond repair or cleaning. They would have to be replaced in order to remediate the problem.
And the contract here itemizes out room by room, living room, kitchen, bathroom, bedrooms, garages, and the grand total is $34,800. Is that a reasonable estimate to use to fix and bring the property back up to an habitable condition?
Actually, that was a bid based upon only what I could see. I did mention to the homeowner that there might be things plumbing-wise, electrical-wise that I couldn't see that would bring that bid up.
Okay, but that $34,800 is a reasonable number that industry people like yourself would charge to make this home usable again.
That is correct.
And without that sort of rehab, what sort of, in your experience, would a single family want to move in there or purchase that home for market value?
No.
Okay. Thank you, Paul, for your time. I have no further questions. Before I leave, Your Honor, I would propose the admission of Petitioner's Exhibit C.
Mr. Macek, is that stipulated or do you object to Exhibit C?
I can't see it, so I mean, is it just his prices? Is that what it is?
I think it's Mr. Schuster's estimate, but can you describe for the written record what this exhibit is?
Yes, it's Mr. Schuster's from Keystone Builders written estimate to Stephanie Frank regarding the repair work the scope of the repair work and the cost to do that work.
All right, so Mr. Macek, I didn't hear your position on that. Further clarification.
No objection. I can't wait to see it if that's something I can view.
All right. With that said, that's admitted, and the court will review that now. All right. Thank you, Ms. Teeley. So, Mr. Flaherty, I think you indicated you're done with your direct for Mr. Schuster. Is that right?
Yes, Your Honor.
All right, Mr. Macek, you now have an opportunity for cross-examination of Mr. Schuster. You don't have to ask him if you don't want to, but it's your choice.
Yeah, I have no questions.
All right. Mr. Schuster, thanks for your service today. You're free to go. Any further witnesses, Mr. Flaherty?
Your Honor, I'd like to call Stephanie Frank, please.
All right. Please rise to be sworn. I'm going to allow you to testify from the council table.
Please raise your right hand. You solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah. Just for the benefit of Mr. Macek being remote, I'll try and use 2 microphones here. So,
I would like to have the camera repositioned.
Let's see if we can do that. Just a moment. We'll try and do that. Okay.
Thank you.
Can you see the witness now, Mr. Macek?
Yes, thank you.
I'll note for the written record, the witness is now visible in the camera shot by Mr. Macek. All right, Mr. Flaherty.
okay. So, Ms. Frank, we got a couple issues to go through that we noticed with this court. I want to go through the bail money first. You heard Tracy Damaris testify that she took $500 and it was short on rent that month because she paid out Mr. Jason's bail money. How did you accommodate that $500 loss?
Her and I split it. So I forgave $250 off of rent, and she gave me $250. So out of the $1,800, she gave me $1,450.
Okay.
Is that right?
$1,350.
$1,350. Sorry, my math.
And if you recall, that was the day that we had a hearing in front of this court, specifically involving that rent.
Yes.
Do you remember requesting this court giving Mr. Macek any instructions regarding Tracy's rent that she's holding for you?
That he was not allowed to divert any rent from me.
Okay. And despite that clear instruction, you were short $500 that month.
Yes.
How did that start the relationship with you and your tenant, Tracy, being a takeover? Were you able to get a deposit back from her?
No.
Who has her deposit?
Jason does.
And did she try and communicate with you about Jason having that, or did you let that issue lie, or did you make efforts to try and get that money?
I asked Jason for it multiple times, especially when the house was going into foreclosure. I asked if he could at least give back the deposit to try and keep it out of foreclosure, and he told me no.
Okay. The house was a disaster, and I see some pictures here on Exhibit B that we pre-marked, and they show what Paul Schuster testified to, essentially, filth and chaos in the house. Who took those pictures?
I did.
And how soon after Tracy Damaris vacating did you take these pictures?
The very next day.
Okay. And if we go through generally Exhibit B, there's several pages. Are these a fair and accurate representation of the condition that she left the house in?
Yes. I would say if you walked through the house, you would probably think it was worse based on the smell that was in the house along with the damage that was done to it.
Okay. And you're still employed at Great Falls School District?
Yes.
And you still have full custody of your 3 children?
Yes.
And you still don't have all your child support from Mr. Macek, do you?
Correct.
Despite that precarious position, well, let's go through the history of this house from September when Damaris left to December.
So Tracy was evicted by the courts in January. She stopped paying rent in September.
Okay. So there was $7,200 unpaid rent?
Yes.
And did you keep the mortgage at least somewhat current and keep out of foreclosure until June of this year?
Yes, I have been making the payments on the house. But when the time the house sold, it was 3 months behind on the mortgage.
Okay. And we'll get into the house selling shortly, but you were able to borrow in money and get the payments of $8,652 paid from January to June.
Yes, I borrowed from multiple people.
Okay.
I'm sorry, what's the total on that?
$8,652 from January to June of 2020 that was paid to the bank.
All right.
And when you never received the deposit of $1,800,
Correct.
and the lender had late fees that were attributable to Mr. Macek's ownership, how do you recall?
The late fees of $855 were on the account when the house was given back to me by the courts.
Okay. And then we have the bail money that was $500 that you didn't recover from Mr. Macek or the tenant. And then we're going to go through, and real quick, Your Honor, I'd like to admit Exhibit B. There's color photos in the court filed, but I have black and white photos regarding the condition the house was when Miss Frank evicted Damaris.
Well, let me check something here. There actually aren't color photos in the court file. There's a list of proposed exhibits filed that has black and white photos. Those don't constitute admitted exhibits. So this is Petitioner's Exhibit B, is that correct?
Yes, Your Honor.
So, Mr. Macek, what is your position regarding the photos that constitute Exhibit B? Do you object or do you stipulate?
I can't see him.
All right, I'm going to ask Mr. Flaherty if he could step toward the camera and show the photos. I've previously ruled that I found your statement credible, that you sent them, but I think he deserves a chance to see the exhibit so he knows what he's objecting to or not. Can you just quickly, well, not quickly, just one by one, show the photos so he knows which photos we're talking about?
Judge Parker, I do have the pictures on my phone in color if you would want to show those to him instead.
Well, I'm going to decline the offer because unless you want to have your phone admitted as an exhibit and placed in the court file, you just pragmatically, you don't want to do that.
Okay.
You're trying to be helpful, but we're not going to do that.
Okay.
Does Mr. Macek have an email address handy that he could look these on a screen since he's on a computer device?
Well, it might be hard for him to look at them at the same time he's using his phone for this court hearing. Mr. Macek, do you have an opportunity to look at email right now, or is that impossible for you since we have the court hearing going?
No, I should be able to.
Okay.
All right.
Do you want me to just type it in to the reporter there?
Well, no, this is just for your own convenience in reviewing the photos. Were you able to see the photos he just showed you?
Yeah, I saw them fine. That was.
So do you object or do you stipulate?
No, we can use those as evidence. I like that. That's good.
So, Exhibit B is now admitted. Mr. Flaherty, you can continue with your exam.
So, Stephanie, after those photos were taken, did you have any feelings on whether or not you could sell the house in that condition?
If I would have tried to sell it in that condition, I think I would have taken a significant loss. I had actually multiple people offer me the opportunity to buy it as a flip home because they wanted to be able to put a very low price on it.
Mr. Flaherty, can I have the admitted exhibits so I can reference them during the course of the testimony?
Sorry, Your Honor.
So if you're going to reference them for the testimony, I've got to be able to assess how much weight I'm going to give those determinations.
I don't know if they're all in the order that they're not marked on there. So I'm not sure which one, you see what I'm saying?
The entire package has been admitted as Exhibit B. So let's just put a sticker on the top photo, please, and then I'll respectfully order that when they're filed, if you could place them all within the same manila folder, we'll know this entire stack constitutes Exhibit B. Do we have the extra binder clip? So when I'm done looking at these, I'm going to provide them to our Deputy Clerk of Court bound so it's clear this is the same stack I've just reviewed. One moment, I'm going to look at these. Let the record reflect I've just reviewed all of the admitted photos, and I looked at them in the order they were given to me, and I'm going to binder clip them in the order they were given to me. That'll, even though they're not numbered, that'll constitute the official order of the photos until such time as someone else unclips them. All right. Mr. Flaherty, you can continue with your direct exam.
So, Ms. Frank, using the real property award as a guide, did you undertake efforts to improve the house and get it ready for sale?
Yes.
And so those back half of those exhibits, those photos, are the after pictures. Is that after you improved it, cleaned, put work into it?
Yes.
And if we take the total of what you've spent into it, first of all, were you able to finance all of that yourself?
No, I had to borrow. People did the work on the front end, and I have to pay them with the closing of the house.
Okay. And some of the things you did, you painted the house for $4,500.
Yep, the entire house was painted.
The flooring that needed to be replaced, do you remember how much the flooring cost were?
Around $17,000.
Okay. And if you refresh your memory here, on your exhibit you have $18,142.62.
Yes, at the end we ended up having to buy some additional carpeting.
Okay. And if you ran through all those totals, how much money between rent, mortgage payments, late fees, and improvements did you put into the property of actual cash?
About 40,000, 42,000.
Okay. And if we include the hours you spent, did you and your family members rehab that property?
Yes.
How many hours have you spent with your family doing that?
Well over 300 cumulative between all of us.
And between the last hearing that was vacated and today, has that property sold?
Yes.
And were you able to get what you feel to be a fair market value out of that?
Yes.
And so I have an itemized list here from you that says the not including labor cost of 325 hours. Since owning that property, it's cost you $49,243.29. How did you come up with that number?
That is the amount of mortgage payments that have been made by me through borrowed money since Tracy and Russell stopped paying rent, and all of the money for repairs to the house that was done from the damage from Tracy and Russell, as well as some repairs to the home that had to be done, necessities for the home to sell. The water heater busted out right before the sale of the house, as well as the water main from the curb stop to the house busted. So that was another repair that had to be done before the house could sell.
Okay, I have a follow-on question just in the interest of saving time. Does the $49,000 figure include the $8,652 that you said that you paid? I want to make sure there's no double counting here.
That includes all
the $8,000 is the money that I have not received from rent from Tracy and Russell.
But is that included within the $49,000 of money you spent to cover mortgage? Do you know what I'm saying? I just have to make sure on this record that I'm not double counting.
I want to make sure I'm following the way that you're saying that. So the $8,000 that I did not receive in rent is included in the $49,000.
All right. That's what I need to know, and that'll probably save Mr. Macek some of his questions. He may have other questions. Mr. Flaherty.
And you had to do the water line replacing. Do you remember how much that cost?
$8,000.
Okay. And just after all of that effort and time and money you put into this property, it sold, and there is actually a profit to be turned after paying off the bank. So the mortgage on the property allowed for equity to be put into an escrow account. Is that right?
Yes. But there, on the statement of expenses, there are things that have not been paid out.
Right. Okay. So the money that the buyer paid off U.S. bank mortgage and the late fees.
Yes.
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 And how much is remaining after the sale of that house? That number doubled. Yeah.
Okay. So total was 57,000. 50% was withheld because of this court proceeding.
Okay. Pursuant to the real property order.
Yes.
Okay. So 57,000 is actually $57,835.78.
Yes.
And that is the profit to be realized, but that does not include your expenses and your time taken out yet.
Correct.
And so if you were to go back from unpaid rent all the way through all the efforts you took, that's that $49,000 number, not including any of your 325 hours of labor.
Correct.
Okay. So the escrow agent released half the money to you, and the other half is being held subject to the real property order.
Correct.
What is your understanding of how you propose this court to allocate the other half?
My understanding is when the house was returned to me, that Mr. Macek was 100% responsible for the damage caused by his tenants, and 50% of any other repairs that needed to be done to the home prior to sale.
So, as a way to encapsulate,
can you repeat that? I didn't understand the question or the answer.
Okay, I'm going to grant him the relief. You wanted the question repeated and the answer. I want to note for everyone, it's almost noon, and we're not going to be done by noon, but I want to get this handled today. I've got another hearing this afternoon that's going to be lengthy. What I'm inclined to do is after the question and answer are repeated, we're going to adjourn for a noon recess. I'd like to just pick this up again at 3:30 this afternoon and close it for everyone's convenience. So, Mr. Flaherty, can you and your client be back here at 3:30?
Do you have a day off work?
I do, but I have children that need to be picked up.
Is there anyone else who can handle that for you?
I will work on it, yes.
I'm not trying to add stress to this situation, but we need to determine what's happening here legally. Mr. Macek, are you available at 3:30 p.m. today?
I believe so.
All right. So I'm going to grant your request. So Mr. Flaherty, please restate the last question, and then I'll hear your client's answer, and then we'll break for the noon recess.
And forgive me if I'm not verbatim here, but the question essentially, Stephanie, is what do you, using the real property order as your guide, what do you understand was supposed to happen with any profit realized from the sale of that house?
That Jason is 100% responsible for the damage caused by his tenants, which were Tracy and Russell, and that prior to the sale of the home, he was responsible for 50% of any repairs that needed to be done to the home to get it sold.
And the purpose of having the Keystone Builders come in right after you took ownership, that's that $35,000 that Paul Schuster testified to.
Yes, and he specifically said he looked only at the damage of the home, not to any upgrades, remodels, literally just the damage that was caused.
And so the additional monies you spent, if we take away and we freeze that $35,000, you brought us up to speed on shared ownership stuff, including the water line was during your ownership, his maintenance, furnace, and those things.
Correct.
Okay, and you understand that would be split 50-50. You and Jason would have the opportunity to pay both those things.
Yes.
And then if there was any profit left off, and there won't be, but if there was, then you and Jason would split the additional 50% profit.
Correct.
Okay. So just with the estimate of Mr. Schuster and the straight cash you put into it, the $57,000 isn't going to leave any actual profit for the sale, is it?
No.
Okay. Those are all the questions I have for Ms. Frank, Your Honor.
Oh, so you've ended your line of direct.
Yeah, because what we noticed at the hearing for was dealing with this money in escrow and how we get that accomplished. So that's our case in chief regarding the $28,000 being held in funds right now.
All right. So here's what we'll do from a procedural standpoint. We're going to adjourn this hearing until 3:30 p.m. When we resume, then Mr. Macek, that's your opportunity for cross-examination of Ms. Frank, and you can ask her about the matter she just testified to, and then she'd have a chance for redirect. Mr. Flaherty, is she your final witness of the day?
I would reserve the right to cross-examine Mr. Macek, but other than Mr. Macek,
all right,
my witnesses are concluded.
All right, Mr. Macek's already advised regarding his witness plan. All right, everyone, enjoy your lunch break. Court will be in recess on this case until 3:30.